morning. Thank you, and may it please the court. I'm Zia Modaber on behalf of the respondents, Sony Music, Michael Jackson's estate. I want to start by saying what I think is obvious. This is not a case about a bag of potato chips or a hammer. We're talking about distribution of core First Amendment protected artistic expression by a public figure. And I'd like to address a quote from the Rogers case to the court and to counsel for Mr. Rovin, the Attorney General. Consumers of artistic works have a dual interest. They have an interest in not being misled, and they also have an interest in enjoying the results of the author's freedom of expression. And I start with this because affirming the Court of Appeals decision is not anti-consumer. It's protecting the rights of everyone, including all consumers, to have free access to First Amendment protected speech. The Michael album receives every bit of First Amendment protection given to a book, a movie, or a political speech. And there are scores of cases that reflect this. I think that imagine art out in the world with no attribution of authorship. Imagine that you just didn't know who it came from or where the source was. It's not the same. There is a character and a quality and the impact and a curiosity even by those who consume the art. Where did this come from? What's the source of this? It adds meaning to it. We want to know who it is. We want to know where it came from. We want to know what inspired it. And part of that is the identity of the artist. And so I can't think of a situation where the identity of the artist doesn't matter. Imagine a situation you have ghostwriters, people who write things under somebody else's name. Obama's book, he didn't write every word of it. Is there a UCL claim for every person who bought the book because he actually didn't write those words? That's the road I think we go down when we start separating the identity of who created the work from the work itself. And we shouldn't be doing that. The First Amendment, the breathing room required for that expression includes the identity of the author. Michael Jackson, almost anything about Michael Jackson, given his fame and given his notoriety, is a matter of public interest. And in this particular case, we have two other public interests or public issues. One is the album itself, just the intense curiosity about what's going to be on this album. It's the first one after he died. What's it going to sound like? What songs are going to be on it? What's it going to be called? What's the album artwork going to look like? All the things that people who are interested in his artistic expression might be interested in. And then there's a very specific public issue here, and that is whether or not Michael's vocals or somebody else's vocals are on these three tracks.
Counsel, on that latter point about the authenticity debate, is there really a sufficient nexus here between the speech and the public issue that you've identified when, as was stated by opposing counsel, there was really no reference to the authenticity dispute and these specific three tracks?
I believe there is, because as this court has said many times and other courts have followed, context matters. And the context here is you have the brewing controversy out in the public in general. You have Howard Weitzman's statement that lays out the issue and what they did to verify it, saying that we believe with 100% certainty, we believe that this is Michael Jackson's vocals, and the fans will make up their own mind. And then you also have, it's on Oprah, and both the album and this issue of whose vocals are on it are being discussed there. And then, as Your Honor said earlier, not only did we put our thumb on the scale when we put the albums on there and said these are Michael Jackson's vocals, I believe we actually jumped on the scale. People are out there trying to decide, is this Michael or is this not Michael? And we picked a side. We said it's Michael, and by inference, certainly we didn't say the words. And by the way, for those of you following the controversy, we think this is Michael. But I don't think that's required anywhere. The context of this is 8 days after the Oprah show, the album comes out and contains these three songs. Given the timing, which is a factor explicitly listed in Filmon, the timing of the speech, given that context, the only credible inference we believe is that, of course, it's speaking to the issue of whether or not this is Michael. And by the way, even if it's not that specific, almost anything that you say about the album contributes to the public discussion about the album.
I mean, just to take the question of innocence, let's say, right, and strict liability, who's in the best position here to know the attribution or to find out?
Well,
I mean, your client is making presumably a lot of money based on this claim, right? And so I'm just kind of wondering, where does who bears the burden, right? In terms of if there is a factual dispute about this, which clearly Sony is aware that there is an issue about this. I'm not saying that Sony is aware of, who, I don't know who actually knows the truth about the vocals, but in terms of the unfairness, right, that's being argued about strict liability, I'm wondering if you could help me with that, because who's in the best position to know?
Sure. Well, none of the parties here were in any position to know, right? The Casios were, and the Casios were sued for fraud because they weren't in a position to know. And it's attached to the complaint, Mr. Weitzman's statement lays out, we did a lot of due diligence, Sony did and the estate did, to try to verify and do what it could to determine whether or not these were Michael Jackson's vocals. And all of the listening sessions they had, listening to the a cappella versions, all of those things were done, and they reached the conclusion that they reached. And in many contexts, the burden should be on the distributor. For an ordinary consumer good, the law is clear. The burden should not be on the consumer. For an ordinary consumer product or commercial product, the burden is on the seller, because they are generally in the position, the best position to know. But that's not the case here. This is not an ordinary consumer product. And just like sometimes there may be harm to a public figure, things could be said about a public figure that might be harmful. When you balance between who should suffer here, we're more afraid of chilling speech in the context of First Amendment, and we should be, in our view, than we are about somebody getting something innocently wrong. Innocent mistakes need to get some protection when you are talking about First Amendment protected expression. That again is why.
I just want to clarify. I've been listening carefully and taking notes here. And when you were talking about prong one, you talked about Sony making statements. I wrote down, we believe with 100% certainty that this is Michael. We jumped on the scale in terms of the division amongst the debate. I see from the record that shortly before the release, Sony publicly expressed complete confidence that these tracks were performed by Michael. But now, in talking about prong two, I hear you to say, well, we really weren't in the best position to know with any certainty whether Michael was the singer or not. It wasn't readily verifiable, but we shouldn't be held accountable. How can it be both? Why is Sony saying with 100% certainty that Michael is the singer if you weren't certain, which is essentially what I hear you to be saying now?
No, I'm not saying that we're not certain. And I want to let me address this. I think there was a lot of commentary about us trying to impose a personal knowledge standard in the analysis between commercial and non-commercial speech. And I want to be very clear. We are not. We are simply reciting the factors that when we have to decide why commercial speech gets less protection than non-commercial speech. Well, why is that? The courts tell us that the reason, there are two main reasons why commercial speech get less protection. Sellers of commercial goods are generally in a better position to know what their products are than somebody else. And that's all we're speaking to, is on that factor we're saying we do not fit that. So if you're looking at that element, that pushes us towards the non-commercial speech side. That is the extent of our point on whether on it's not even verifiability. It's really that's shorthand for it, but it's really in a position to know or the exact language of Kasky. So that's all we're saying there. And the other important factor, of course, is chilling. Those two things.
Yeah, I'm still not seeing how they're reconciled, because I still hear you to be saying Sony said we were 100% certainty that this is Michael, but at the same time, Sony should not be held liable for any alleged misstatements because you finished the sentence. Because why?
Because they can be liable, just not under strict liability theory. And they can be liable under negligence or other fault theory because this is non-commercial speech. And why is it non-commercial speech? Look at whether we were in a position to know what the content was. And in that case, we were not in the best position, like the maker, like Nike was, to know the condition of its workers. Nike's in a position to know. The person who makes a lock and manufactures the lock, they actually make the lock. That isn't what happened here. We had to rely on a number of other factors, right? Michael's not alive. We have the recordings, so we brought in experts. We did everything we could to figure it out, and we reached the conclusion that it was Michael. And so we put it out as Michael. Because if you don't call it Michael,
but the Attorney General says to that, there's an easy solution for this, which is don't just say we're 100% certain it's Michael. Say, we believe it's Michael, but there are these other factors that the public should be aware about that Mr. Modabar is telling the court about now, so he didn't tell you about the time, that made it impossible for us to verify with 100% certainty, and you should know that as well.
Well, we did put that out in the statement, first of all, but I think the response to that is, the First Amendment gives you the right to speak, and it also gives you the right not to speak. In the PG&E case, the U.S. Supreme Court says as much. We can't be forced to put on and sticker an album with a belief that we don't hold. We don't hold the belief that there's a question about whether or not this is Michael. That's not the belief we held. And to force us to put it out there violates the First Amendment as much as forcing us or not allowing us to say something. And that's the answer, and it's discussed in a little bit further detail in our brief, but putting us in the position of having to take or espouse our opponent's side or somebody who disagrees with what we believe is not permitted under the First Amendment either.
I had understood the Attorney General's suggestion and the suggestion in the briefing to be just sort of a statement that these 3 disputed tracks are believed to be performed by Michael Jackson. But, sort of given the circumstances under which the recordings were made, the belief would be understandable to a consumer. How is that inconsistent with Sony's position about the authenticity of the tracks? It's an expression of belief that seems consistent with these beliefs.
And again, I think forcing us to put that on there when we are talking about core First Amendment speech, again, is forcing us to change what we are putting out there. And again, if this was a bag of potato chips, we make people label consumer goods all the time. But this is different, and we are talking about, again, the identity of an author, which is part and parcel of the art itself. So you're really boxing us in and forcing us on fully protected speech to say things. And I don't think it's permitted under the First Amendment.
So I understand that argument to be backing away a little bit from the response you just gave Justice Grantham. So the problem isn't that this response compels you to say something that you disagree with. You're instead saying that the problem is that it compels you to say anything at all that is not what you would otherwise want to say.
I may have misunderstood, but I thought the first question you asked was, why don't you just say, this might not be Michael? And that, to us, is forced, compelled speech of something, of a belief that we don't hold. Now, if you're saying, just make a neutral statement, which is the refinement that I think you gave, and so I refined my answer a bit to say that I think even forcing us to say that is not permitted under the First Amendment when we're talking about the expression itself. If we were talking about a bag of potato chips, if we were talking about another consumer good where the identity of the author was not part and parcel of the work, I think you could push somebody to say you need to put that on there. But the question here is not whether there's liability at all. It's whether there can be strict liability by just getting it wrong.
Let's see it.